Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, for you sports fans out there, you guys ever watch a game, your team's not playing in it, but the two teams that are, you hate both with a passion, and you can't really root for one of them to win, and you wish they both could lose? That's not going to happen, so you just end up, rooting for injuries. And for those of you in the Southeast Conference, you know what I'm talking about. Well, I'm going to introduce you to a lawsuit today that involves a couple of parties that would normally be on the same side, but for whatever reason are actually in litigation against each other today. It's a weird case. It's got a bunch of weird arguments. It's got even a weirder ruling. And this is something that everyone should probably at least get a little entertainment out of. So today, let's spend a few minutes and let's talk about the worst lawsuit you will ever read. I bet you wish you could go and do this every day, but you don't, do you? And I imagine you wish your groups looked a lot like this, but they don't, do they? No, instead they have a tendency to look a little bit more like this. Plus, you might have noticed that this stuff ain't very cheap anymore. Or, just hear me out, you can use your Mantis X10 Elite training system like I do. Listen, this thing is way too easy to use. Step 1, install the Mantis training app to your smartphone. Step 2, install the Mantis X10 Elite training system to your firearm. It's as simple as this. Step 3, open up the training app, select your program, and away you go. Listen, you can practice in the comfort of your own home. This app will store all the data. It will tell you what you're doing wrong, what you're doing right. It will tell you what you're improving on and what you need to work on. The best part is, all you need is your firearm and the Mantis X10. You don't need any ammunition, and you don't need any expensive membership to a range or a gun club. And right now, if you want to check this revolutionary system out, all you got to do is click on that link right up there. For more information, visit our good friends at mantisx.com. Okay, what are we talking about today? Check out the name of this case. This case is called State of California versus ATF. Yes, that's right. That is the name of the lawsuit, the State of California versus ATF. It should be called Al-Qaeda versus ISIS. Now, what could the State of California possibly be suing ATF over? Like what? You're not shoving enough civilian disarmament down the throats of Americans? Well, actually, that's exactly what they're suing. Yeah, this goes back to ATF's Rule 2021R-05F. You go, what the heck was that? Well, that was the ATF's rule on unfinished frames and receivers. And what the state of California, along with their co-plaintiffs at the Giffords Law Center did, is they sued the ATF in the United States District Court for the Northern District of California and basically said, hey, you know what? Your rule on frames and receivers was a little inconsistent, and candidly, the category of materials that you could have been regulating is much, much larger. You didn't take into account a bunch of other things, and for that reason, we're asking that the court enjoin that portion of the rule and then force it back to the ATF to go back to the drawing board. Now, you're sitting there going, wait a second. Hasn't there been a bunch of other courts that have struck down this rule and completely vacated it in its entirety? Well, yeah, that's true, but why would the state of California ever want to let that get in the way of arguing for more civilian disarmament? Let me give you an idea, though, of where the court is coming from on this. The issue in the case at bar, however, is narrow, though important and potentially consequential. It does not concern the general merits or constitutionality of gun control legislation. Rather, the question before this court concerns the legality of two specific aspects of ATF's technical regulations and rulings addressing ghost guns. ATF has ruled that the regulatory provisions of the Gun Control Act apply to certain parts used to assemble a fully functioning firearm under some circumstances, but not others. Plaintiffs challenge the lines drawn by the ATF in this regard, mindful of the deference generally afforded to agency regulations implementing a statute. The court, for the reasons stated below, upholds one part of the challenge regulation rulings, but finds another portion invalid. Now, without getting way too deep in the woods, this deals with ATF example number 4, which dealt with a framer receiver that had not been particularly milled out and was not sold with any jigs, tools, or other types of components necessary to convert it into a finished frame or receiver. But the court has found ATF is still not fully complying with federal law because it has unlawfully determined that many partially complete AR-style receivers, the fundamental component of deadly AR-style assault rifles, are not firearms under the Gun Control Act. For those of you who actually were geeking out on the channel back when we were talking about the rule on unfinished frames and receivers, you will recall that one of the criteria the ATF was going to look at is how readily restorable was a chunk of material into a finished frame or receiver. And one of the things that the ATF said they were going to look at is, was that frame or receiver, or in this case unfinished frame or receiver, sold then with all the parts and the tools and the jigs and all of those things necessary to then turn it into a completed piece. And we had pointed out that there was an anomaly in the language that ATF had chosen in that criteria. It was this: even when a sample is not classified as a receiver or firearm, that determination can change if it is sold, distributed, marketed, possessed, or otherwise made available with any associated templates, jigs, molds, equipments, tools, instructions, or guides, such as within a receiver parts kit. And so what California is saying is listen, that language suggests that if the raw material is not sold with any jigs, tools, or instructions, things like that, it automatically is not a frame or receiver. But what if all of that stuff necessary to turn it into a frame or receiver is readily available, but just from a different private party, a different retailer, which is exactly what we had pointed out when we started talking about this on this video right here. And so what the state of California also argued is hey, listen, ATF, you made this finding that if the holes that needed to be drilled out and some of the other things that needed to be done were indexed, marked on the device, thus making it more readily convertible to, that would constitute a frame or receiver. If you know that there's these other items out there and there are all these jigs and instructions and tools and everything in kits out there but are being sold separately, why then would that not constitute a frame or receiver? And so what the state of California successfully argued here is that the ATF has violated the Administrative Procedure Act, but not in the way we normally talk about it, where, man, you guys have gone way out of your lane. You have exceeded any authority that Congress ever gave you. You are regulating things that no one has ever given you authority to regulate. No, instead, this time, what California argued is hey, you guys are not regulating enough. And let us remember that there would have been a standing challenge, right? Why does the state of California, why does Giffords Law Center get to actually sue the ATF? How do they have standing? Well, California argued that, because the ATF is not regulating these things enough, we're spending resources to regulate these things, so that's our injury. And then this is the truth here. You can look it up. We're going to link this ruling up down below so you can read it for yourself. Giffords Law Center said that, hey, listen, we could be working on trying to disarm civilians in other ways, but since the ATF is still kind of loosey-goosey on this thing, we're having to spend our time and resources trying to ban more of these ghost guns, and that's our injury. And believe it or not, the court bought off on both. And so the court, specifically with this example number 4 that we've talked about, has come to the following conclusion. For the reasons stated above, plaintiffs have several meritorious arguments. 1, ATF's determination regarding partially complete receivers that are not machined or indexed and not sold with jigs or tools, see example number 4, were made without taking into account all relevant data, including the factors listed in 27 CFR section 478.11, which defines readily for purposes of readily converted. And 2, ATF has failed to explain why it is not regulating such partially complete receivers, given that jigs and tools are easily obtainable. And so what the court has ruled here, and this is a little bit of rearranging the deck furniture on the Titanic, is that all rules related to example number 4 are put on pause and have to go back to the drawing board. The exact language of the court was, the court agrees with the plaintiffs that ATF's actions related to example 4 are arbitrary and capricious in failing to take into account all 8 factors related to the readily assessment in particular time and in failing to address the impact of easy availability of jigs and tools from sources other than the seller or distributor of the incomplete receiver. The court therefore, 1, declares one subsection of the final rule, example 4, and related agency actions to be unlawful and enjoins defendants from enforcing them. 2, vacates one subsection of the final rule, example 4, and related agency actions. And 3, remands to the ATF for further proceedings consistent with this court's opinion. Now, some of you may recall California was one of the first states to pass all sorts of bans on ghost guns, unserialized firearms, privately made firearms, whatever you want to call it. And that was going to save lives. Apparently, that's not quite working yet because the state of California has now sued the ATF saying you need to do more enforcement. Now, I will point out that while this is a really interesting ruling, there are other jurisdictions that have found far greater problems with this and well beyond one tiny little section. Okay, the case once again is State of California versus ATF. We will link it up down below. Have a little bourbon, do some breathing exercises, grab a barf bag or anything like that before you sit down to read it. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is down there in the description box as well. And then let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.